The appointment of a retired Supreme Court judge, Justice Nazeer, as Governor of Andhra Pradesh has become the latest flashpoint between the government and the opposition. Opposition leaders say it sets a bad precedent if a judge of the Supreme Court is awarded with a plump posting just a few days after his retirement. The government has refuted the charges, with the law minister blaming the ecosystem for the attack. So what exactly has happened? Justice Abdul Nazeer, a Supreme Court judge who was on the bench of prominent cases like the Ayodhya judgment, triple talaq matter, right to privacy, and even whether demonetization was legal, retired on 4th of Jan this year. On the 12th of February, President Draupadi Murmu announced the appointment of 6 new governors and made changes in governors in 7 states. Justice Abdul Nazeer was on the list as Governor of Andhra Pradesh. Now, the opposition has called this a threat to an independent judiciary and says it's a blot on democracy. Some have even asked the retired judge not to accept the position. But why the concern? Simply put, judges, especially in the Supreme Court, often find themselves passing judgment on matters where the government of the day is in the dock. In some cases, their judgment could impact decisions government makes. Very often, the government is a party in those cases. So, will the prospect of a plump post like that of a governor end up swaying the decisions a top judge makes as he or she nears retirement? To illustrate this point, several opposition leaders today quoted a statement made by the late Arun Jaitley on this issue.
This whole temptation of continuing to occupy a litigant's bungalow is a very serious temptation. And therefore, kindly review that unless it's absolutely essential, either some of these tribunals must be subsumed into the judicial setup, pay the judges who have retired and retired judges a pension equal to their last drawn pay. Because the danger is greater, the desire of a post-retirement job influences pre-retirement judgments. It's a threat to the independence of judiciary. And once it influences pre-retirement judgments, it adversely impacts on the functioning of our judiciary itself.
All right, so that's what the late Arun Jaitley said. And of course, top opposition leaders are today citing this once again. But what are the rules? And this is important. Nothing in the Constitution per se forbids judges from taking up a specific post after retirement. Other judges have also found themselves in what could be considered a plump post. A similar controversy erupted in 2020 when former Chief Justice of India Ranjan Gogoi was nominated to the Rajya Sabha by the President. Even then, it was pointed out that there's no rule saying a former judge can't hold a constitutional position that would effectively be granted by the government. The BJP today is also citing past examples of this happening. Let's in fact listen in to some of the reactions that have come in today.
कांग्रेस पार्टी के समय भी कई नियुक्तियां इस प्रकार की होती रही हैं। भारतीय जनता पार्टी के द्वारा नियुक्त किए गए ये जजेस उसी परंपरा का हिस्सा है। हम इसको ठीक नहीं ठहराते।
मैं समझता हूं कि पहले बात तो ये है कि अब्दुल नज़ीर साहब बहुत एक उम्दा जज थे। उनके यहाँ मेरे को बहस करने का बहुत मौका मिला और मगर फिर भी मैं समझता हूं कि या तो कन्वेंशन होनी चाहिए, अगर सब भी पार्टीज का इस बात के ऊपर राजीमंदी हो जाए, ऐसी बातों को से छुटकारा पाने के लिए एक कानून ही बना देना चाहिए कि पोस्ट रिटायरमेंट जॉब पहले 2 साल में नहीं मिल सकती।
Yeah, that is the landmark judgment which favors the BJP. So they have their own men who speak of who can speak like Ravi, our governor, who can ill-treat the state elected governments, who can thereby ill-treating the people who had elected them, insulting the people who had elected them as governors. It is all an insult to the people. In a democracy, people are the bosses. They elect a state government. The governors insult the government, that government, which means they are insulting the people who had elected the government.
तो मैं तो समझता हूँ कि ये राजभवन जो है ये राजा भवन के रूप में तब्दील हो गया, इसकी कोई आवश्यकता नहीं है। पूरी की पूरी सरकार वो चलाना चाहते हैं, सारे तंत्र पे वो डंडा चलाना चाहते हैं। इसलिए मेरा तो अपना मत है कि ये तो बंद ही हो जाना चाहिए, राज्यपाल और एलजी। और दूसरी चीज क्या है, जो व्यक्ति बीजेपी में 50 साल तक काम किया है, अब किसी काम का नहीं बचा, आपने उसको राज्यपाल बना।
कांग्रेस को राम जन्मभूमि से कब से प्यार हो गया? अभी अगर मंत्री परिषद में कोई मुसलमान नहीं है तो प्रश्न उठाएंगे कि मंत्री परिषद में कोई मुसलमान नहीं। अगर कोई पार्लियामेंट का चुनाव कोई मुसलमान नहीं लड़ा तो कांग्रेस और सब लोग प्रश्न खड़ा करेंगे। अगर हमने राज्यपाल बनाया तो हम अच्छे लोगों को चुन करके बनाते हैं, जो मुझे अच्छा लगता है। इसमें लोगों को एतराज किया, हम जब नहीं बनाते हैं तो प्रश्न खड़ा करते, अच्छे लोगों को बनाते हैं तो उसे ये मानने को तैयार नहीं।
All right, I'm speaking first with Abhishek Manu Singhvi this evening, senior advocate and MP in the Rajya Sabha from the Congress party, and of course, senior jurist. Mr. Abhishek Manu Singhvi, thank you so much for speaking with us on Beyond the Headline. Now, you have invoked, and other leaders have invoked Arun Jaitley on this issue, the late Arun Jaitley, and also said you have nothing personal against Justice Nazeer. Can you explain to us what the issue is?
No, it is. It's much wider than just what Arun said. Let me explain. First and foremost, it is not about people, personalities, individuals. Matter of fact, I know the judge is a fine gentleman. I'm nothing against the judge, and in fact, he has been a very fine man. The issue is about principle. It's time we had this principle that we will not give political or non-judicial appointments to retired judges. Remember, the independence of judiciary, which this implicates, is part of the basic structure of the Indian Constitution, so held in innumerable cases. And the meaning of basic structure is that you and I, even by a constitutional amendment, cannot amend the Constitution if it affects or impinges upon the basic structure. Now, the problem is, Tamanna, that there are 3 or 4 such appointments in quick succession. All the appointments are to political and semi-political posts. All the appointments involve persons who have handled and have handled in a very deep way highly political, sensitive, and sensational cases. And this diminution of stature of the most important vital organ of the judiciary is as much by perception, by appearance, by feeling. It doesn't have to be by actual proof. So I think this needs to be completely avoided. And of course, I mean, you can only quote to your political adversaries what they have themselves said repeatedly. Post-retirement appointments affect pre-retirement judgments. Now, it is whataboutery. It is political whataboutery and not satisfactory to say you did it in the hoary past, so I'm doing it. Yes, there were some appointments like that, but the atmosphere was certainly not as politically surcharged as it is today. And even it was done, I think this political whataboutery of 2, 3, 5 wrongs make one right is just not on. So I think these are the various 6, 7 facets.
Mr. Singhvi, the current law minister has responded to this criticism and said the whole ecosystem is once again in full swing on the appointment of a governor. They should understand that they can no more treat India as their personal fiefdom. Now, India will be guided by the people of India as per the provisions of the Constitution. What he seems to suggest is that the Constitution does not prohibit this, that a judge can be appointed post-retirement as a governor. How would you respond to that?
If you leave aside the last line of the law minister and repeat each of the earlier lines you just said, tell me a single answer to the issue at hand, except for political rhetoric, except for political whataboutery, except for digression about lobbies and about Lutyens Delhi. There's nothing in that reply. Number 2, certainly 9/10 of good constitutional governance is based on following the spirit of the Constitution, on not allowing the spirit of the Constitution to be decimated, following conventions, following good practices. None of those 90% is written in the Constitution. Britain, in fact, functions without a written Constitution altogether. And before it joined the European Convention, there was no written document. Now, only for a few constitutional matters, the European Charter, before Brexit, used to be the document. Would they get up and say, look, it's not written in the Constitution, so I'll appoint every retiring judge? Is that a logic? The same law minister, unfortunately, has been saying that the basic structure could be junked or trashed. The same law minister has been saying that they should be, despite 3 judgments of the NJAC Supreme Court Constitution benches, despite 3 judgments, he's saying every day that they should have a representative in the collegium of the Supreme Court. Now, just because you hold an office in the government doesn't make you right. It, in fact, betrays a glorified innocence and ignorance of the way Indian Constitution functions, more importantly, on the way Indian jurisprudence has been laid down.
But what exactly is the concern? If this has been happening, there is no constitutional prohibition against it. What is the concern? What do you think will be the impact of this on the judiciary?
The larger concern, as I said, is nothing to do with individuals, it's to do with principle. Hard cases make bad law. Good persons appointed on a wrong precedent will allow bad persons to be appointed tomorrow on the same wrong precedent. Today, the simple, short, blunt answer to your question, Tamanna, is that people, you, others, your friends, will look over their shoulders, especially during the sunset clause time, which is near retirement, looking over their shoulders to the various plum fruits of the political dispensation available. I'm not saying this gentleman did. I'm saying the matter of principle, which will establish, will be highly prejudicial and deleterious, in fact, destructive of the very independence of judiciary, and really comes to the same point. Post-retirement benefits, lollipops and posts will affect your pre-retirement thinking, whether it starts affecting you 1 year before retirement, 18 months before retirement, or 6 months. And remember here, it's no point doing another set of political whatabouteries. One is that it happened in the past. Second is, but there are judicial appointments made. Judicial appointments to tribunals, they stand on a still different footing. These are political or semi-political appointments, and we can't lose sight of that.
You're saying it's political or semi-political, but the position of governor is gubernatorial at the end of the day. It's a constitutional position for an eminent person, and a retired Supreme Court judge is an eminent person.
Tamanna, are you or am I living in an ivory tower? Have you smelled the coffee or have I missed that? You read every day in the newspapers what governors are doing. You read every day in the newspapers what a gubernatorial post involves. If you consider that to be a sanitized, distant, non-political post, well, I think then we are living in a cloud cuckoo land. Today, governors are in the thick of the political melting pot. Governors are, whether they do it or not is not the point, are repeatedly daily being directed, forced, instructed to do the bidding of their political appointees. There are governors who have exceeded the Lakshman Rekha brazenly. There are others who are near the line, and there are a few exceptions. But that's the individual case. Don't call it a judicial adjudicatory post which you're getting after retirement.
So do you think Justice Nazeer should reject it, Mr. Singhvi? Many are saying this on social media, that he should not accept. What is your view?
Well, I'm nobody to advise him or instruct him. I'm saying a matter of principle, since there's no way the government has the magnanimity to accept its mistake. There is no other option if you want to uphold that principle. I think his stature. Do you know that H.R. Khanna, who had in many ways been wronged by supersession, and I say it clearly, even though a Congress regime had wronged him, did become the law minister for 2 days, the law minister of India, a political post. 2 days or a week, I forget. But when he's advised and told, he resigned. Now that has made him immortal. It has not affected anything else. So, I mean, these are precedents to be kept in mind.
All right. Thank you so much, Mr. Abhishek Manu Singhvi, for speaking with us. We're going to take that conversation further. Tehseen Poonawalla is with me today, our political analyst. Rahul Mehra, senior Supreme Court lawyer. Ashwini Kumar Dubey, advocate in the Supreme Court. And Dr. Justice Satish Chandra, former judge, is with me on the show. I welcome all of you. Thank you so much for speaking with us. Justice Satish Chandra, let me begin by getting your take on this, because here we're talking today about judges and whether after retiring there should at least be a cool-off period. Are there some positions they should simply not take? Now, it seems fairly apparent that if you are in a position where you may get some sort of a plum posting or some advantage from one of the parties that you have to pass judgment on, it will impede you as a judge, wouldn't it, sir?
Yeah, about the merit of Justice Nazeer, there can't be two opinions. He is an excellent person, excellent jurist, and he was holding a constitutional position and has come to the constitutional position and another position. And now the criticism, because the constitution is saying for the appointment of the governor, only Indian citizen is required with the 35 years of age. And after the retirement, a judge has become eligible for that one. He is an Indian citizen and holding about the 35 years of age. So he has not committed any crime and he can come equivalent to other candidature and they can do so. And this is not a new thing. What controversy is created today. In the Congress regime, J. Faisal Ali, in 1952, he was the governor of Odisha High Court, Justice Madam Fatima Bibi, right. 97 to 2001. She was also the governor. O.P. Verma, judge of Kerala, was the Punjab governor. But you know,
Justice Chandra, may I 1 minute. Justice Chandra, I understand what you're saying, sir. And of course, Justice Nazir is, you know, a pre-eminent judge. Everyone in the fraternity, Abhishek Manu Singhvi also said he has great respect for him. But the question is not about Justice Abdul Nazeer today. I want to ask you, because you have been a judge, if there is, you know, some kind of an advantage or a plum position or a posting at the end of your tenure or as a judge after that, will it not influence the decisions you make before retirement? That's the question.
Madam, certainly not. Because in the instant case, Nazeer was a part of the bench, which was the 5 judges bench. He was merely a member, and that was a constitutional bench. And that judgment is the judgment of the Supreme Court, not of Mr. Nazeer, not individuals. So merely a member of a particular bench, it can't say so. And about the cooling period, what they were talking, I will tell you that about 28 tribunals are there, and 3 or 4 positions like the National Human Rights Commissions, where statutory requirement is this, that there should be headed by a High Court judge or Supreme Court judge, or member should be a High Court judge. So this is the requirement of the Act itself. And Supreme Court itself has rejected the prayer that there will be a cooling period. So after rejection by the Supreme Court, there is no need of the cooling period. And it is for the government and individual whether he will accept or not. And it is for the government to appoint or not to appoint. That is there.
No, but that's hardly answering the question at hand today. Rahul Mehra, you know, it's okay. So the Constitution does not forbid it. The court itself doesn't want a cooling period. It has happened before. These are the 3 core counter arguments. How would you respond to that? Especially when there seems to be a broad consensus that no one can, you know, point a finger at the individual himself in this case.
I don't think it's about the individual concerned. It's about the principle, and the principle is very simple. If you want a thriving, independent, impartial judiciary, then instances of the kind that we are discussing and debating today need to be shunned, and individuals concerned who have taken the oath that they shall forever be bound by that oath of delivering justice without fear of favor, without affection or ill will. Now, the moment you accept it, and nobody is talking about the individual concerned out here, But the moment you accept it, and that too within a few days of your retirement, then there are going to be insinuations, there are going to be allegations, there are going to be rumors that probably there was some quid pro quo. So it is neither in the interest of the institution, out in this case judiciary, which reposes, or ordinary citizen reposes faith in judiciary only on the ground of perception. We need to understand that. And the perception is what? Perception is that we will get a free and fair trial. We will get an independent judiciary which will look into the matter of the primary litigant being a government, and government is the most litigious client because 80% probably, or more than 60% of the cases are that of the government, be it the state or the center. And therefore, it will be a neutral arbiter and it will decide the matter on the facts of the case and not like Mr. Arun Jaitley. Forget anybody else in this matter. Let's just take the statement of Arun Jaitley, who was a tall leader of this political establishment, which is ruling the government today. He said in unequivocal terms on the floor of the House that post-retirement jobs influence pre-retirement judgments. Now, if you want to cloud your Ayodhya judgment and various other judgments and give fodder to people that yes, there could have been something out there, maybe there's nothing, absolutely nothing. But you're actually playing in the hands of the critiques, hands of the opposition. When instantly, when the person demits office, you give these kind of posts, and that too political posts.
Ashwini Dubey.
These are not quasi-political. These are 100% political posts. Imagine who is the governor? Who is the appointed governor? The political establishment, the tallest leaders or leaders on the past who have contributed to that political outfit are the ones who are given this as a largesse.
But it's not necessary, Rahul, Mehra, that only someone who has contributed politically become governor. They are maybe trying to make a point that we've chosen an eminent personality.
Most of the times because these are political, which is why an eminent personality must not, and that too somebody from judiciary must not accept these political posts, because now every decision taken by Justice Nazeer will be looked from the prism of what? That whether he's impartial towards the government in power, or is he playing as a tool in the hands of the government? Does he really want to reduce himself to that? And as I said, it is not about the individual, it is about the institution. It's a bad principle.
If it's not about the individual, it's about the institution, and the perception must be above board of every judgment a judge has passed, even after his or her retirement. This surely clouds that question, isn't it? Everyone is now looking back at everything Justice Abdul Nazeer did, or the judgments he passed in the last few months, in the last few years.
Look. Who is making this hue and cry? Is this the people of the state of Andhra Pradesh? Is this the Chief Minister of Andhra Pradesh? It is only a pressure to build a moral pressure to resign. Now see, in 6 years of his career in Supreme Court, he has been part of a multiple incredibly impactful constitution bench cases. Even you see, so far the judgment of demonetization is concerned, it was authored by Honorable Justice B.R. Gavai. It was even not authored by him. There are 4-1. What people are talking about? Not only this, in triple talaq case, he gave the dissenting view. Not only this, you just talk about the right to privacy and validity of Aadhaar. He was one of the judge. And so far as the Ram Mandir is concerned, it was not only the judgment has been delivered on the basis of any.
But Ashwini Dubey, if it's not 1 minute, you're repeating exactly what Justice Chandra said. You're repeating exactly what Justice Chandra said, but it doesn't answer the question if it's not about Justice Nazeer. Suppose in Justice Nazeer's case, this was the right decision. But is it a bad precedent?
Of course not.
Will this create doubt in the minds of sitting judges? Will this create an untoward pressure in the minds of sitting judges to go easy when It's the government in the dock. That's at the end of the day what the people want to know. Will their hands be pulled back?
One of the finest judge, Honorable Justice Chandra, who was part of the Ayodhya judgment, is Chief Justice of India. Now, do we raise the doubt on his integrity? This is question one. Second, when Sarkaria Commission was set up in 1983 to look into the center-state relations, proposed that Vice President of India, Speaker of Lok Sabha, should be consulted by the Prime Minister in the selection of the governor. Was this brought into effect? And is there any private member's bill which was brought into effect which says that the Supreme Court judges or retired High Court judges should not have any constitutional post? Then you must amend the law. NCDRC, Armed Forces Tribunal, Lokayuk, PMLA Tribunal, NGT, NCLAT, Minority Commission, NHRC. So bring a law. Who is objecting it? But making it, look, see, Justice Abdul Nazeer is from a humble background. He rose, he became the Supreme Court judge. How do you counter the judgment, other judgments? The judgment which talk about the rights of the backward
there's no reason to counter, there's no reason to question Justice Nazeer. Just saying that this is a bad precedent when there is already a number of occasions where this has happened, is it really going to be enough? Is there an ecosystem out there, as the law minister says, who's trying to push an agenda?
Has to be looked into by the ecosystem created by
Tehseen, that question's for Tehseen. He's listened patiently. It's his turn now. Yes, Tehseen.
Good evening, Tamanna. Thank you so much for having me on the show, and good evening to all my fellow panelists and to all your viewers. First, I think it would be injustice to smell a quid pro quo to Justice Nazeer becoming the Governor of Andhra Pradesh. And I think he's going to bring a lot of dignity and to the post that he's been assigned to. The question is not about an individual. The question is about a system. A bad system that sends good people in, the same bad system can very be easily used to send terrible people in. So it's not about people, it's about systems. Now, the only justification that I've seen is, A, by the learned retired judge, that the Congress did this in the past. Two wrongs do not make a right. It was a terrible thing the Congress did. And therefore, our constitution is called a living document, and democracy is always supposed to evolve. So in post-2014, when Arun Jaitley ji, when he was in opposition, spoke, and I quote him, post-retirement job hunting, and Mr. Modi ji spoke about the independence of judiciary, the then Prime Minister challenged Mr. Modi should have said that the new India that I'm envisaging will be exactly like the old India that was behind, and I will create the same, and I will blame it on old India. Then you would not have called it New India, and you would not have got the 300 seats. You promised something different. Even if you didn't, democracy is supposed to evolve. It cannot be the same. It cannot be stagnant. Let's come to the second allegation that is being made, or the second point. Look, once again, this isn't about the individual called Justice Nazeer. This is about the system. And like the judge very smartly got in the tribunals on board, got in the NHRC. Those are mandated by law to have retired judges. Nobody is talking about tribunals or NHRC. We are talking about political appointments. All you have to do is go to Tamil Nadu and see what the governor is doing. All you have to do is go to Karnataka and Chhattisgarh. The very same.
Do you think Justice Nazeer will play that kind of a role in Andhra Pradesh? No. Do you think Justice Nazeer will play that kind of a role in Andhra Pradesh?
Doesn't matter. I believe he will.
Are you saying that might happen?
No, I believe he will. I'm saying that he will bring dignity to the office. But even then, a good person cannot come in through a bad route, because then the bad route will be used and justified to bring a terrible person in. And therefore, the good person must avoid that temptation and not come in through a bad route. There must be a cooling down system. But here is the problem, Tamanna. My two opponents on the other side of the debate are bringing in the Congress. And I'm telling you, no political party, including the Arvind Kejriwal-led government, which is today in power, will bring in a law if they come into power. Therefore, the only solution is this, that the Supreme Court revisits its judgment and brings in a cooling off period for 2 years for tribunals and 3 years for political appointment. Because unless the Supreme Court does not step in, the majesty of the court, which should be the highest, will always come into question, and motives, unfortunately, will be attributed, though none should be attributed.
Yeah, Ashwini Dubey, do you want to respond to that? It's not about the person, it's about the process. And today we're talking about Justice Abdul Nazeer. I have not heard through the day a single person raise a finger or point a finger at this individual's integrity. Yet, It is now at the top of headlines. All of his judgments are facing scrutiny. We're talking about what he did, and inferences are being made. Surely it's something he doesn't deserve. And surely there is some kind of a change. If there was a cooling off period, at least there would be no opportunity to say something like this.
Tamanna, I, as a student of law, don't oppose this. But the question is, when Article 153 of the Constitution of India says that there shall be a governor for each state, and Article 157 to 158 specify the eligibility requirements for the post of governor, which says that the governor must be a citizen of India, be at least 35 years of age, not be a member of either House of the Parliament or House of the Legislature, not hold any office of profit. Then don't you think there is a need to amend those provisions of the Constitution? This is point number one. Point number two, being the custodian of the Constitution and being the governor who is the executive head of that particular state, don't you think that we need a finest judge who can understand, interpret the Constitution, who can understand the law of the land, and who can aid and advise the chief minister? Point number three, the chief minister is the state's head and who represent the majority, who represent the public at large. Chief minister would have been having the dissenting view at the first instance. Chief minister says, we welcome this decision. Who I or Tehseen to oppose this? Point number four, unless there is a law.
1 minute. That's 1 minute. Let me get a response to that point. Instead of so many points, let me just get a response to that specific point. Tehseen, the chief minister of the state is happy. The primary opposition leader in that state is happy. They have both, welcomed the appointment of Justice Nazeer as Governor of Andhra Pradesh. Then why does everyone else have an issue?
Let me just tell this by a small story. There was once a minor accident outside the Mirror Now studio. A mob caught him. They saw the car driver was wrong. They beat him up completely. They beat him to pulp. Everyone went home happy. Happiness is not a barometer for legality and morality. Happiness is a barometer for yourself. Legality and morality are above that. And we cannot have legality sans morality. And if Justice Nazeer's judgments are today being called into question on Mirror Now, it is terrible for Justice Nazeer. It's terrible for him. He shouldn't.
No, there is no legal question here.
Therefore, I'm saying legality cannot. There is, because legality cannot stand without morality. And it is unfortunate that his legal judgments are today being discussed when he does not deserve it. I think his judgments are fabulous. I agree with his Ram Janmabhoomi judgment. But unfortunately, he's been dragged into a legal conspiracy or legal debate only because of morality. And therefore, in the Mahabharata, Vyasa writes, you cannot have legality without morality. Morality is an essential part of legality. Simply taking away morality from legality is empty words, and that never stands. It always calls into questions your actions.
Dr. Justice Satish Chandra, do you think there should be at least a cooling off period? It's better for the judiciary. Not everyone may be of the same caliber as the judge we are talking about. Why create a temptation? Why create a situation where judges don't feel like they can do their job correctly, either for fear of consequence or for favor? There should be no fear or favor.
The present circumstances, and by looking at the precedent, the appointment is okay. Appointment is okay. Who have the heart burning, let them challenge in the Supreme Court. And the Supreme Court will decide it. And regarding the cooling period, the Supreme Court has already refused it. They said that the demand and supply, the available vacancy and the person available, it depends on that one. Demand and supply. So that is there. And precedent is there from 1952 to till date. And unnecessarily they made the issue of this one. And Andhra people,
it's an unnecessary issue. Rahul, Mehra, it's an unnecessary issue. There is enough precedent. And if you reverse the argument, do you think it's fair for an individual to be put out of the running for a position like the governor if they deserve it just because they have been a judge?
Nobody can dictate.
Rahul Mehra, question to Rahul Mehra. Yes.
Tamanna, I strongly believe this is absolutely a wrong convention. This is not a precedent. This is not some judicial finding or something. This is a convention. It's a wrong convention. If Congress in the past has done it, and we all know Congress in the past and There was a time period when even emergency was invoked. We don't want an emergency just because Congress invoked emergency, do we? So therefore, those are wrong conventions, and we must understand that. I'll give you 3-4 quick points in 10 seconds. Number one, do we agree that there is a tendency from the government of the day to even not accept the basic structure, and independence of judiciary is the basic structure? Do we accept that the government of the day is trying to have a committed judiciary by having a full say in the appointment of judges? Do we also accept that the position of governor, which is a totally political position given to the so-called karyakartas and the political leaders of the day of the political outfit, those are the offices which are being thoroughly abused, and these are governors and lieutenant governors which are being pitched up against duly elected governments to axe their own political grind? And therefore, I say this particular aspect, there has to be a cooling off period, no question about it. First of all, these offices should not come to judiciary, even if they are given, even if they are on a platter handed over to a retired judge. They should have the dignity, and they should step aside, they should step back in the larger interest of insulating their own institution, which needs to be protected from the political masters who are egging and edging to get a political say in the judicial framework of our country. Therefore, it is for the institution, it is for the judges to protect their own institution. Obviously, given a say, all political masters of the day would like to have a committed judiciary to axe their own grind, to grind their own axe, to have their own political agenda, and to do their own stuff, in future.
One particular
Rahul,
Mehra, can I just point out? Can I just point out one thing?
Allow me last 5 seconds, and I'm concluding.
Yes.
There is, under the Constitution, when a governor is appointed, he holds the office during the pleasure of the president. Now, the pleasure of the president, the moment the government of the day changes in the center, or what happens? The governors also, the heads roll. So therefore, that goes to show just one and plain simple one thing, that these are political appointments, and rather than being falling in the trap of a political master who would like to embrace and show that and give you a jadoo ki chhappi, you should keep an arm's length from such political masters in order to give sanctity and give that perception to the people, which is important.
The only point I was making, Rahul Mehra, if the position of governor is as political as you say, and many opposition leaders say this, that has become a very political position, is given to the karyakartas or to people who will further the government's agenda, then in that sense, from that point of view, Justice Abdul Nazeer seems a very poor choice. Then it could have been bestowed upon someone more likely. They don't have to give it to a retired judge.
So Tamanna, I'm not going to, the last word is still not out. I hope Justice Nazeer steps aside, does not fall in this trap. But if that happens, then every single decision of Justice Nazeer from here on will be minutely followed, debated, talked about, discussed, and dissected. And the public opinion is going to be the last word on it. So therefore, why put yourself in such a situation?
Tehseen wants to come in. Tehseen, the point of cutting out Justice Abdul Nazeer as a candidate just because he was a judge. Maybe he is the right person.
Maybe. And I think, why maybe? I think 100% he's the right person. I certainly have no heartburn. I can say that for a fact. My fitness levels are good, so I need no medicine. The question out here is, a good person coming in through a wrong system is wrong, is terrible. It shouldn't happen. That makes it easy for wrong people to come in through wrong systems. What should happen is a good person should come into the good system. So I am sure there are so many other judges as competent, as integral as Justice Nazeer who have crossed 2 years in retirement. Let them come in and take in as governor. And if the most honorable Prime Minister 2024 wins again, 2 years are up, let Justice Nazeer come in as a governor, or whoever becomes, let Justice Nazeer come in after 2 years. I think that this good system is more important than good people. We should always be system-centric, not people-centered. I repeat, I have no heartburn. I'm fantastically
Will anyone
fit.
go to court to review the cooling off period? That's the question the judge on this panel asked. Kitni dikkat hai to then go back to court. Rahul, Mehra, would you go back to court to say let's have a cooling off period? Because if there is a serious concern, it has to go beyond these TV debates.
Okay, so there are two things. There is a conflict. According to me, there is a conflict of interest for the parliament because every single politician would want a committed judiciary. So therefore, that law, I don't see it coming. Unless and until all political heads, all leaders across political parties sit down together and they say, yes, we want independence of judiciary, I don't see it happening. That's one. It's an oxymoron. Number two, for the judiciary, I think it is important that in order to have that respect amongst the people, because your biggest stakeholder is the ordinary citizen of this country, you must introspect and you must look into the aspect of how, even if you want to assume such positions, which according to me is a big no, but still if you want to debate...
will you go to court? Will anyone who has got a problem with this go to court and ask for a review of the cooling off period judgment?
None of us have a problem with something like this. It is for the interests of the institution. How is it going to impact you or me?
No.
It is for protecting the institution, the judiciary. It's not like a political master. Politics is not looked upon in this country. Politicians are not looked upon in this country. Judiciary is.
It's not answering my question, though. How are we going to fix this?
I want to answer that.
How are we going to fix it? Because our viewers will, at the end of the day, after listening to this entire conversation, want to know कि इसका होने क्या वाला है. If nothing's going to happen, then let's wish each other good night and I'll take a break.
Madam, there are two types of
some use of it. I
did think about going to court. I'll be very serious. I did think about this, not just in this case, a couple of other cases, but under what law? Because the law is not broken. However, the law is sans morality. So the legality, it'll stand the test of legality. It does not stand the test of morality. That is the problem. Now, what the Supreme Court interprets is the written word of law. What the Supreme Court can do suo motu, and where I agree with Rahul Mehra, since no politician or parliament is going to do it, is say, look, while this is a law, the Supreme Court in its wisdom has taught no judges can take over High Court or Supreme Court 2 years post-retirement, but there are several other integral judges who are available. So there will always be enough supply of judges and you give a two-year cooling period. Because there is no law violated for me to go to court and challenge. The court cannot make a new law. The court can only strike down a law that is ultra-vires of the Constitution.
The court will probably also have to see precedents. If there is any precedence of an appointment of a judge to any of these positions, having a negative impact either on the judiciary or, a problem which is against the Constitution, there has to be a precedence. Yes, Justice Chandra.
The Supreme Court said that there is no need of the cooling period. But Supreme Court has not distinguished between the appointments. There are two types of appointment. One is the statutory, for example, the quasi-judicial bodies like tribunals, national judicial commissions, where it is mandatory that they should be headed by a High Court
judge. It's a judge.
So there is no need of any cooling period on those appointments. Regarding the political appointments like the governor and others, I think there will be no harm if there will be a cooling period of 6 months or at least 1 year.
Okay, so we're coming to some kind of a consensus on this panel. I always like it when that happens. Ashwini Dubey, should there be a cooling off period at least for positions which are quasi-political appointments? Forget the tribunals because they have to have a judge on it.
Not only this, even I do say that the Law Commission's 1958 report should be implemented in its true spirit. The Sarkaria Commission's report should be implemented. The Punchi Committee proposal should be implemented. And then only we can say that, yes, there is an independence of all three organs and all three organs of the constitutions are working in the best interest by the people.
So there may be a case to look at a cooling off period, at least when it comes to positions like that of the governor. Let's see where the story goes. And meanwhile, I think, one thing to take heart from is that there seems to be a near consensus and a complete consensus, really, that Justice Abdul Nazeer was an exemplary judge
and perhaps
will make a great governor. I have to wrap it here. I'm going to take a very short break. But